Welcome, everyone, and thank you for participating in today's webinar hosted by the National Latina Network for Healthy Families and Communities, a project of Casa Esperanza that builds bridges and connections among research, practice, and policy to advance effective responses to eliminate domestic violence and to promote healthy relationships within Latino families and communities. My name is Jose Juan Lara Jr., team member of the National Latina Network, and I'm joined by Rosie Galgo, Senior Public Policy Director for Casa Esperanza National Latina Network, and your host for today's part 2 of a 2-part webinar series. The webinar series is part of Casa Esperanza's National Latina Network Enhancing Cultural Responsiveness in the Courts Training Project, through which we provide training and technical assistance focusing on enhancing access to justice by fostering more culturally responsive courts, court staff, and judges. In today's webinar titled Protections in Court Proceedings and Sensitive Locations for Immigrant Survivors of Domestic and Sexual Violence under VAWA Confidentiality Protections. But before we start, I want to review a few housekeeping details. Participants have been automatically placed on mute. As an extra precaution, we ask that you also do the same. If you are joining us using an agency phone and have hold music, please be aware it will be heard if you need to put the call on hold. If you have any questions, please submit them in the chat box. We will also be providing closed captioning. This webinar will be recorded and uploaded to the National Latina Network website. Any resources mentioned will be sent to participants, including an evaluation after the webinar. We kindly ask that you complete the evaluation since this helps in shaping future content for our webinars. If you'd like to register and join our listserv, you can go to our website, nationallatinanetwork.org. With that, I'd like to introduce our presenter. Lesley Orlov is an adjunct professor and director of the National Immigrant Women's Advocacy Project at the American University Washington College of Law. With that, I'd like to pass it over to Rosie. Rosie?
Good afternoon. This is Rosie Galgo. I'm a Senior Director of Public Policy at Casa Esperanza National Latina Network for Healthy Families and Communities. And I want to start off just by thanking you so much. I know everyone's really busy, and we really appreciate that you're taking the time to join us for this webinar and know that you're going to receive a lot of real valuable information during this presentation by Lesley. But also really want to encourage you to participate actively through some of the different polls that will come up, as well as in the chat box. There's a chat box to ask questions, and we know that there's a variety of levels of expertise by people joining the call. Some are newer to learning all about these different VAWA immigration remedies and VAWA confidentiality provisions. Others may have more expertise, so feel free at all different levels to ask whatever question or to share information that you think is helpful to the group so we can make this interactive. As Jose Juan mentioned, this is part 2 of a webinar series. Last Monday, we had the opportunity to do part 1, which was focused on the role of the judge in cases of immigrant DV and sexual assault and working with immigrant survivors in that context. And Lesley was a co-presenter with Judge Weir. I hope a lot of you had an opportunity to hear that webinar last week. But if you didn't, we will also be sending out the link to that webinar as well as the PowerPoint and materials. And it really provided a very good overview of some of the critical VAWA immigration provisions, about the role of judges, particularly in custody cases where this might come up, or in determinations for special immigrant juvenile status. We talked about the important role of judges in certifying for a U visa potentially. So a lot of really helpful information about the judge's role in cases involving immigrant survivors. And today is part 2 of that, where we're going to focus more today on issues of VAWA confidentiality and the protections included in VAWA, the Violence Against Women Act, regarding access to safety and justice for immigrant survivors. And so we really just want to highlight how critical it is to recognize that Congress, in a bipartisan manner, created these special remedies back in '94 when VAWA was first passed, and in each subsequent reauthorization of VAWA in 2000, 2005, 2013, these different provisions and protections and the VAWA confidentiality, have consistently been strengthened. And, and gaps that have been identified, we continue to work to really strengthen that. But really importantly is to make sure that those of us in the field at all different levels, whether you're a victim service provider, whether you're in law enforcement, in the courts, prosecutors, all court administrators, that we really ensure that people have knowledge about these immigration remedies and these confidentiality protections, because that's really the only way to make sure that they're being implemented and that we're addressing both the critical vulnerability that immigrant survivors face as well as the barriers they face to accessing safety and justice, and the way that many times abusers seek to exploit immigration status to sharpen the tool of abusers. So this information today, I encourage you both to use it, but also to share it out with others. We're going to be sending you, again, the link to both webinars, both PowerPoints, and other materials, and we encourage you to share that throughout your systems, your coordinated community response system, so that all individuals are aware of the important role they play in implementing and ensuring that there's access to safety and justice for immigrant survivors. And before we continue, I also just want to mention, we have received some inquiries from individuals, knowing that VAWA is up for reauthorization in 2018, wanting to know what the impact is on these VAWA immigration remedies or VAWA confidentiality. So I do just want to reiterate that because those are provisions written into the statute that are not linked to grant programs, they're not linked to funding that needs to be reauthorized every 5 years. These are provisions that are, in the statute and continue to remain in effect, even as we see other parts of VAWA that are for reauthorization, or as appropriators, decide the type of money to allocate to grant programs. That does not impact these provisions. So we need to make sure that that information is out there, that people know. We need to keep, referring immigrant survivors to those who can assist them in a myriad of ways to access these important remedies, and that we all continue to lift up the VAWA confidentiality provisions. So without further ado, I'm going to hand it over to Lesley, who has tremendous expertise, has been working on the front lines and in the field and policy and in national training for decades. And Lesley's going to launch into this presentation. And again, please interact via the polls and via any questions you have in the chat box. So Lesley, I'll hand it over to you now.
Thank you, Rosie. And if I'm understanding correctly, this is supported by a grant from the Office on Violence Against Women, this webinar.
That's correct, through the Justice for Families Grant Program.
Great. So my name is Lesley Orlov, and I direct the National Immigrant Women's Advocacy Project. We call it NEWAP. Rocio Molina was supposed to be with us today, and I'm apologizing on her behalf. She had a university-related event that was mandatory that she could not move. So I'm here on behalf of both of us, and we offer training and technical assistance on a wide variety of issues surrounding surrounding the legal rights of immigrant survivors of domestic violence, sexual assault, child abuse, elder abuse, human trafficking, stalking, and dating violence. And as I said, we're going to focus today on VAWA confidentiality, and Rosie explained that this is part of a two-part series. What I will do, though, as we get started, want to get a sense of who's on the line, and also get you, so we're going to be doing some polls, and there's going to be some questions in the chat box as well. So those of you that, could you please answer the poll as to which of these most closely represent the work that you do, and then those of you that are writing other, please type other in the chat box as to what other is. So it looks like most of you are victim advocates, and there's a few lawyers and a few people from the courts, and those of you, and then we have somebody, a public policy coordinator, somebody from Superior Court, civil legal advocate, immigration paralegal. Okay, great. I think I ended it. Whoops. There we go. Okay, so what we're going to do, our objectives for the next about hour and 15 minutes, is we're going to talk, by the end of the webinar, you'll be able to take steps to help immigrant victims of domestic and sexual violence receive VAWA confidentiality protection. And that's true about whether you're a judge or court staff. It's also true whether you're a victim advocate or attorney. Judges will be better able to rule on, and lawyers will be able to file objections to motions or so there'll be, ruling and filing objections to and seeking pretrial rulings on discovery related to VAWA confidentiality protected information. So whatever position you're in, the information we'll provide you will help you advocate for victims, if you're a victim advocate or an attorney, or if you're a judge, help you rule on the motions that come before you around this area of the law. You'll also be able to respond effectively should an immigrant victim become a target of immigration enforcement at a protected location. And we're going to be talking about what are protected locations under VAWA confidentiality laws and other policies that Immigration and Customs Enforcement have in place. So many victims of domestic and sexual violence and other crimes are eligible for forms of immigration relief. And the kinds of criminal activities that those victims may have suffered include this list. Some of you may be familiar that most of this list is really coming from the VAWA, the U visa, but domestic and sexual violence, spouse abuse, child abuse are covered not only by immigration relief that's available to victims, but also by VAWA confidentiality protections. So just as we get started, and when you think about the numbers of people that you either hear in the cases that come before you, if you're a judge or you're at a court, or work on as a victim, work on with regard to a victim, a parent, or a child has suffered one or more of the criminal activities that we had listed. Can we do a poll and get a sense of what percentage of the cases you see fall in this category? Marissa, is it putting the poll up? Hold on. So what percentage of the cases that you hear involve crime victims, parents, or children of crime victims? Great. So it looks like over 50%. Great. That's yeah. Over 50% on that poll. That would be that. So you're seeing these fairly regularly. Excellent. Can we close the? Okay. So what's important as we start off is to understand that there's a wide range of protections that immigrant crime victims may be subject to, may have as protection based on the abuse they've suffered. Now, since we're talking about VAWA confidentiality, what I wanted to do is this is a good tool for screening, but the three types of cases kind of on the top right there's three of these cases that are covered by VAWA confidentiality's protections and three that are not. So VAWA confidentiality applies to the T visa, the U visa, and the VAWA self-petition. It also applies to spouses of certain work visa holders who are abused, and we'll go over that. But it doesn't apply to asylum, SIJS, and continued presence. Those are forms of immigration relief that may help other crime victims. Special immigrant juvenile status, for example, helps immigrant children who've been abused, abandoned, or neglected by one of their parents. VAWA confidentiality would cover them as being victims of abuse, but not abandonment or neglect. And continued presence is a form of immigration relief for trafficking victims that is not directly covered by VAWA confidentiality in the same way that the T visa is, and we'll talk about that. So, and we're going to be focusing on VAWA confidentiality and how it intersects with the courts. So we're going to be talking about discovery, we're going to be talking about courthouse enforcement, but in order to understand this, I'm going to start off by giving you more of a background about why we have VAWA confidentiality laws. So VAWA confidentiality has, as Rosie mentioned in the opening, has always been bipartisan. Actually, the first VAWA confidentiality law as to immigration went in effect in 1996. It was not part of original VAWA. Original VAWA had some rules they had some funding to look into address confidentiality and some things like that. But the immigration provisions started in 1996, and they started as a bipartisan response by Congress to what they were seeing happening in cases of VAWA self-petitioners. Now, VAWA self-petitioners are people who are abused, abandoned, who are subject to battery or extreme cruelty by their U.S. citizen or lawful permanent resident spouse or parent. And in some, it also covers some elder abuse cases where the abuser is the over 21-year-old son or daughter who's a citizen. And they created these provisions because abusers were using the immigration court case filing system to stalk abusers, to retaliate if they found an immigration case had been initiated, and to use information in those files against the victim. And so these provisions were designed to ensure that abusers and criminals could not use the immigration system against their victims. And in 2005, when the legislative history of the VAWA Confidentiality was written, Chairman Sensenbrenner and Ranking Member Conyers said that jointly that the committee wanted to ensure that immigration enforcement agents and government officials do not rely on perpetrator-provided information to apprehend, detain, or attempt to remove victims of domestic violence, sexual assault, and trafficking as prohibited by VAWA confidentiality laws. Can I have the yes-no polls, Marissa? So while she puts them up, I'm going to ask two yes-no questions. I'm waiting for the polls. So the first one is, have you, and if you could move it, okay, so have you worked with domestic violence or sexual assault victims who have been contacted by immigration enforcement officials? So it's yes or no. Can you check off participate in the poll? Looks like about slightly more than half of you have not, but about half of you have responded so far have. Okay, can we go to the next one, Marissa? And the next one, we end this poll. And the next one, she'll just do a yes, no. And then the question is, if I can see it, the question is, have you been has your client been contacted by immigration officials? So there's one where perpetrators have threatened to do it, and the other one is whether or not they've been contacted. And again, this one's looking slightly more of you have had your clients contacted than less, but it's a small number of you have answered. Okay, let's end the poll and go to the next.
Lesley, I'm wondering, I think we did the contact one twice. I'm wondering if we can, Marissa, put up the poll to ask about whether they received threats of deportation from perpetrators, if we could ask yes or no on that one.
That would be good, Rosie. It's hard for me to catch them when I'm looking at the screen.
Yeah. I think the question is, have immigrant survivors with whom you've been working received threats of deportation from the perpetrators, saying they would contact ICE and have them deported? So answer yes or no whether, so we're saying yeah. I'll let you go ahead and respond to that.
Right. So here, thank you, Rosie. Here, what we're seeing is many of you have worked with clients or heard cases where people are threatening kind of deportation, where you've heard that that's part of the evidence of the case. That's what I would expect to see, that this happens in a very large number of cases. Thank you, Marissa. But that the number of people actually contacted by immigration officials was actually lower. That's what we would expect to see in these cases. But that number was still relatively, it was half of you that answered the question. So VAWA confidentiality was designed because Congress understood threats of deportation were being continuously used by perpetrators to silence victims and to keep them from cooperating, from seeking help and cooperating with immigration enforcement officials. And, excuse me, and cooperating with law enforcement officials. And they would use threats of deportation so that people don't call the police for help, they don't seek protection orders, They aren't able to go, or they're less able to go forward in a custody case, for example, because they're threatening that if you bring the custody case, I'll turn you in and I'll get the kids and you'll never see them again. So VAWA confidentiality was designed to address the perpetrator's efforts to interfere in the immigration case in several different ways. The first one is that I'm going to talk about these generally, and then we're going to delve into them in more detail as we go through the webinar. The first one is what one typically thinks of is as non-disclosure provisions. And what they are is it basically says if you file a VAWA confidentiality protected case, if the victim files a case, that case is kept confidential. It is logged into a computer system that I'll talk to you about later that warns immigration enforcement officials and others that this is a VAWA confidentiality protected case. And it applies to any case so it applies to VAWA self-petitions, U visas, T visas, and work authorization cases filed by spouses of work visa holders who have family member spousal visas. The second prong of VAWA confidentiality, and that applies, you have to file a case for that to happen because you have to have a case that has information that would be protected, and it protects the information about the existence of the case, about any decisions made in the case, and everything contained in the case. The only exception, the only thing that might be discoverable in a criminal proceeding is the certification itself in a U visa case. And we'll go into that in much more detail when we talk about discovery. The second prong of VAWA confidentiality is the prohibition on relying upon perpetrator-provided information. And what this says is that DHS officials and immigration court officials and State Department officials cannot rely on information that they receive from the perpetrator, the perpetrator's family member, or their agents. And this one, though, the non-reliance of perpetrator-provided information, again, I'll go into more detail, applies to every case of spouse abuse or child abuse without regard to whether or not the victim filed an immigration case. The problem is that enforcing those provisions for domestic violence cases where there's been a spouse or child is difficult when a case hasn't been filed in the system, and we'll be talking about it. But as a technical matter of the law protects victims without regard to whether the case has been filed if the case is spouse abuse or child abuse. All other victims, it protects them when they're in the process of filing an application for VAWA, for U or T, because VAWA self-petitioning cases will always be spouse or child abuse, and the work visa holders will always be spouse abuse. So that you don't have to wait until the case is filed on this last prong. That's a new interpretation of that provision that followed the issuance of the regulation, the form and the policies on those work visa holder cases that came out in February 2017. So that's the non-reliance on perpetrator-provided information. I'll explain that a little bit more in a few minutes. And then there are locational provisions, and that means that so that DHS officials are not allowed to do immigration enforcement. This applies to all victims who are eligible for VAWA, T, or U visa cases, and it requires that no action be taken, and all spouse or child abuse victims, and it requires that no action be taken against the victim at a protected location based on information provided from the perpetrator. And then there's a list of locations that are covered. We'll talk about that more in a little bit. And that if they initiate an enforcement action against the victim, which immigration lawyers call NTAs, notices to appear, if they initiate that notice to appear, they have to swear out an affidavit as part of the notice, articulating that they did, telling the judge, that the immigration judge, that they did not and how they did not rely on perpetrator-provided information. So these, again, are the three parts of them. The perpetrator-provided information piece, if the perpetrator, let's say, gave them a tip, and the tip was, you can pick up my wife at this street corner, they would have to find an independent way to corroborate that that information. But if the tip was, my husband's convicted of armed robbery, then they can go to NCIC, the criminal database, and verify in NCIC that she has that criminal record, and then can proceed on that criminal record because of the information about the fact that she's got a criminal history has independently been verified. And there are a couple of there are safeguards that they have if they're going to do an immigration enforcement at a protected location. There are safeguards and procedures, like certain locations require that they get supervisor approval. So there's various things they have to go through if they're going to try and do enforcement action in a protected location. And the non-disclosures I mentioned applies to the Department of Homeland Security, Department of Justice, the State Department, and then if DHS does release any information to anyone under any of the exceptions, let's say for national security purposes or for law enforcement purposes, the DHS policies require that person receiving the information is required to maintain its confidentiality, continue to maintain the confidentiality of the information, so they can't just hand it over to the abuser. So DHS VAWA victim confidentiality protections apply. There are statutes, regulations, and policies. We have a whole document that will be in the materials we give you where it traces each of these three categories. So it talks about, there's a section where you can see all of the statutes, regulations, and policies that apply to the abuser-provided information prohibition. Then you can look up separately the locational prohibitions and separately the non-disclosure prohibitions. And it goes through everything Department of Homeland Security has ever written on this. It quotes all and cites and links to all of the policies. The only policy it doesn't cover is one internal policy that's not been released publicly because it has to do with the national security databases. So VAWA confidentiality applies to all of these cases. So self-petitioners under immigration law applies to battered spouse waivers as well. VAWA cancellation of removal, VAWA suspension of deportation, U visas, T visas, and then spouses of work visa holders who apply for employment authorization. And it applies to, as I said earlier, everybody who's a victim of spouse or child abuse. It also applies to children that are included in the application. So it's not just the victim themselves, but any children that might be included in their application as VAWA self-petitioners or U visas are also covered. So all of these cases, once they get filed, they go into a computerized system at the Department of Homeland Security that is it's called the 384 computer system or the red flag system. And what this does, this was developed so that Department of Homeland Security, immigration enforcement agents and adjudication agents could see that this was a red flag case. This was a case that VAWA's confidentiality applies to. And the information available in that system is very little. You put in the person's name, and it comes back as covered by the system. And you can't tell whether that person is a victim of domestic violence, human trafficking, sexual assault, felonious assault, extortion. You can't tell. They can just see it's a protected case, which means special rules apply to that victim. And this is very important because, as I said earlier, VAWA confidentiality can apply, or does apply statutorily, to spouse abuse and child abuse victims, whether or not they filed. The problem is that immigration enforcement officials have no this is once you file, it gets put into a system that tells the enforcement officials that this is a case entitled to VAWA confidentiality protection, as opposed to being somebody who claims it. And it's just in this day and age, and for many years, it's been hard to get this VAWA confidentiality protection to work in any administration for victims before they file. So it's really important to file. These protections work best when the victim gets her VAWA self-petition, the U visa, the T visa, or the work authorization filed. There are some cases of VAWA self-petitioners that are also covered by the Cuban Adjustment Act, the Haitian Refugee Immigration Fairness Act, and NACARA. But this is the full list of who gets that red flag system when their case gets filed. So what's important is now turning to the fact that, so U visa and T visa victims, and even VAWA self-petitioning victims, you can invoke VAWA confidentiality if they can if they encounter an immigration enforcement issue, enforcement officer, if they tell the officer that they're in the process, or show them that they're in the process of filing a VAWA self-petition, a U visa, or a T visa. That triggers VAWA confidentiality and the officer's obligations to at least inquire as to whether or not this is a crime victim. And they're supposed to, according to policies, at that point go consult with a supervisor before they move forward. And so the evidence, what we encourage people to do is, if you're an advocate or attorney, you're working with a victim that's getting ready to file a case, that you actually write a letter saying they're in the process of filing a VAWA or T or U visa case, that the victim can then show an enforcement official if she's encountered. The other thing that somebody could carry around is if they've got a U visa certification, they could carry a copy of the U visa certification. And if they've previously gotten a protection order, having a copy of the protection order on them is important. Now, I know a lot of you victim advocates are going, whoa, what about the perpetrator learning from her about, because they find the paper. So it's a balancing issue. It's a safety planning issue. It's important to think about how she can safely carry these things with her. But if she's receiving threats of deportation in the relationship, it is important to have something on her that she could show should Immigration and Customs Enforcement stop her, because without the paper, it's very difficult to convince officers at the time, at the scene of a stop, that she is actually a victim. And for victims, in cases where victims have already filed, once the case gets filed, they get an A number, and if they memorize their A number, they can give any officer that stops them their A number, which is another way to give them notice that her case is in the VAWA confidentiality protected system. And as I said earlier, victims of spouse abuse and child abuse and immigrant parents of child abuse victims, they could be covered now. But it's very, by statute, but it's hard to make these provisions work absent an initial filing. When immigration enforcement officials violate VAWA confidentiality, each violation is a potential $5,000 fine or disciplinary action against the individual. I know that DHS has actually taken disciplinary actions against a number of officials, demotions and things like that, as a result of VAWA confidentiality violations. And that if you have a case of VAWA confidentiality where you think it's been violated, we provide national technical assistance on that, and the Office of Civil Rights and Civil Liberties is responsible for enforcing VAWA confidentiality violations, and you or I or anyone could file a complaint about a particular case and have them investigate. And when they investigate, they can see the computer systems, everything kind of behind the scenes at DHS. So if you have a case of a client where you've already filed the U visa or the VAWA self-petition, and they got a tip to pick the victim up at the courthouse, let's say they were appearing for a protection order case or a custody case or something, the civil rights, civil liberties people that do the investigations can see that they never check the system that they were supposed to check, or they can see that they checked them, and despite knowing that the case was red flag, they went after her. Either of those, so it gives them important information in terms of enforcement of the VAWA confidentiality provisions. In addition, in June of 2018, ICE confirmed that the victim witness memo that was issued in 2011 is still in effect, that is designed to encourage actions against crime victims. Again, it is not as strong as VAWA confidentiality, because it's not statutory, but it is, some advocates have been able to use it to get prosecutorial discretion, not to enforce immigration laws against victims, but it is much less effective. It's not the most effective thing to use today, and you shouldn't be relying on this instead of getting a VAWA T or U visa case filed. And as for those judges on the call, as we talked in the last webinar about U visa certification by judges, judges can be one of the people who can sign U visa certifications, and then when government officials sign them for certifications, that's the prerequisite in U visa cases to victims filing, and it's one of the things that helps get them in the system so their case will show up red flagged when their perpetrator should their perpetrator try to call ICE on the victim. So let's take a pause here, and for those of you, I see some of you, I asked earlier where you're from to get you a little bit using the chat box. I'd like you to take a moment in the chat box and tell us why how these protections might be important to courts or family, to what might be the impact on courts, or how might it be important for courts to know about VAWA confidentiality protections. Some people typing. Nope, they stopped. Anybody have any ideas? Rosie, can I call on you for some ideas so they don't all come from me?
Yeah, sure. I mean, I think as we've seen, Lesley, oftentimes an abuser is looking for tools to threaten someone so that they don't seek out the kinds of protections that they're entitled to by law. So we do hear a lot of times that, an abusive spouse or another perpetrator will tell an immigrant victim that if she goes to court, she will be arrested. And for example, she might have a custody case, a child support case, an order of protection case, and the abuser will say, I'm going to call ICE and let them know that you're going to be in court that day. So if you show up, they're going to arrest you. And so we see that. And in fact, we had done a survey of the field last year that revealed there's just so much uncertainty. A very high percentage of advocates and attorneys, close to 75%, said they had cases working with immigrant survivors where the survivor had expressed great fear of either calling the police or of going to court, and about 43% said they had survivors who had dropped cases because of fears. So I think this definitely impacts access to the courts, and that kind of misinformation is really a sharp tool that abusers can use.
Right, exactly. And we've done research that's found similar fall-off. Interestingly, though, in the research that we did last year, one of the things we found, which was really interesting, is that in recent years, these fears of deportation are working pretty effectively to convince some, particularly VAWA self-petitioners and some U visa victims, not to file the immigration case because the victim is too afraid. So, but where they work with advocates and attorneys, and those advocates and attorneys have experience in the court system, we're seeing that there's actually very little change over the years in protection order uses, because advocates and attorneys are, A, doing good safety planning, and B, convincing victims from their own experiences and the way the courts treat their clients that they're going to be able to get access to justice despite the fact that they're an immigrant or limited English proficient, and that in courts where, like, judges are signing U visa certifications or doing special immigrant juvenile status findings, those courts are actually seeing increases in victims willing to use the court system. But it's a combination of the work of victim advocates and courts being open and having a reputation for being a safe place that victims can come. And we'll be talking about how steps courts can take to send those messages and the important role that victim advocates and attorneys play in that as well.
Leslie, now you mentioned that, if I could highlight a case that even was covered in the Washington Post last year that I think is really descriptive of this. And this was a victim of sexual assault who had filed criminal charges out in Baltimore. And in her case, it was actually the defense attorney for the accused who contacted her and essentially threatened her, said that if she showed up to testify against the defendant, that ICE would be notified, and reminded her that ICE could be seen in the courthouse and that she stood the risk of being deported. And to Leslie's point, because this survivor knew that she was supported by, advocates and that in that city, in that jurisdiction, there was really a message that all immigrant victims should, come forward, both for individual safety and for public safety. This immigrant survivor actually reported it to the prosecutor that the defense attorney was making this threat. And ultimately, they actually put a wire on her and asked her to talk to the defense attorney again. And he did reiterate that. And when the day of the court trial came, they actually arrested the defense attorney in the courthouse. And it was public, it came out in the newspapers. The Washington Post did an article about it. So, we see how there are individuals who sadly might even include a defense attorney that could try to raise those kinds of threats. And that's why, like Lesley said, if we're in jurisdictions that really send the message to all survivors that they deserve access to safety and justice and protection, then, those people won't be too afraid to come forward, and we can hold accountable those who are doing those kinds of threats.
And there's training for judges on all of these types of power dynamics. We're involved in them in a number of ways. I know you are too, CASA and other organizations. So that's a really great example of how this can play out. And so VAWA Confidentiality can promote access to justice. It can tell courts to be ready and expect that perpetrators and know how to respond as a matter of law if perpetrators try to use state court discovery to obtain information that's VAWA confidentiality protected, and that knowledge of protected locations is also really important so courts can order, let's say, visitation exchange at a place that has got VAWA confidentiality protection or sensitive location protection, as opposed to some place where that protection doesn't exist. So, for example, if you order exchange of the children at a church, then there's sensitive location protection for all immigrants at that location against immigration enforcement. But if you order it at a police department, there isn't. So, and that courthouses are prohibited locations under VAWA confidentiality laws that we'll be talking about in the latter part of the webinar. So for attorneys and advocates, some tips and tools. You want to identify VAWA T and U visa victims as soon as possible. You want to file their immigration case as soon as possible. But it's important that you, in rushing to file it, that you file a well-documented case that will meet the prima facie test and will not just get denied because it doesn't have enough evidence. So you want to file, and a well-documented case means, evidence of, will usually involve, a victim's affidavit, maybe some police reports, maybe medical history and things like that. But ideally, you want to file the immigration case before the case in the family court gets filed, because what happens is when the perpetrator when the victim files a family court case, or if there's a criminal case that they're getting ready to appear in and is going forward, that's the time at which the perpetrator gets notice, and they're most likely to pick up the phone and try to call ICE in retaliation. And so if the case is already filed, then it will be in the 384 computer system and protected. As I mentioned earlier,
if I could interrupt, we have a question here from a participant that's saying, if a victim has no papers, so if they're undocumented and they don't have U or T visa, what happens if the abuser exposes that victim?
Well, if they're a victim of domestic violence, sexual assault, human trafficking, or any of the list of U visa criminal activities, then they should be eligible to file. And if they're a victim and they haven't filed yet, if they filed a police report, for example, they should have a copy of that. If not, it's very hard to convince ICE that they're a victim and not just an undocumented immigrant. So to make these laws work for the victim, they're going to need some evidence of abuse. That's the way the law is structured. It's supposed, if it's a spouse abuse or child abuse victim, you may be able to advocate. Other than that, it's very difficult. So that's why I'm saying it's really important to file these cases as soon as possible and file well-documented cases. Otherwise, they're left out in the open for the potential of immigration enforcement, because if you think about it on the other side, if I'm an immigration officer and I get a call about an immigrant who's thus and such location, then, I might go. The priority right now is people with open criminal case and convictions. So if I'm working with a client that has a criminal conviction or an open immigration case against them, or a removal order against them, it's even more important that I file the immigration case based on their victimization as soon as possible. And then once they file, they can carry the A letter. You can give them, the victim, a letter saying you're working on their VAWA TNU, that as I mentioned. If you're really worried about it, and let's say you're going to court, you might take a copy of the certification with you. You might take a copy of the ICE and DHS VAWA confidentiality policies with you to show the officer if somebody tries to stop your victim at the courthouse. All of those links, all of those materials will be on the web page that we put up of materials, so you can download the DHS policies and take them with you. And that, as I started to say, that victims, the groups of victims that these protections work less effectively for are victims with criminal histories, arrest, outstanding deportation orders, and people who've not filed yet. So I cannot emphasize enough how important it is to file as soon as you can. And for courts on the call, the role that courts obviously, judges can't tell people to go file things, but they can. The courts can make information available, and there are very good Department of Homeland Security brochures, including the shield-like thing that I showed you in the beginning with the multicolors, that courts can distribute with other public information at the courthouses, and that that way they can help distribute information so that for some people, the courts are the first responder with an interpreter. That, with a qualified interpreter. So that might be the first place a victim has a chance about learning about her legal rights. And so courts can play an important role in that. Okay. So we're going to now go on to VAWA Confidentiality and Discovery. So now we're going to that first prong that I showed you earlier, talking about how VAWA confidentiality prohibits the disclosure of any information about the existence of a VAWA T or U visa application, information contained in what they call the A file, which is the immigration case file, and about any actions taken in this case. And the disclosure is important. It prohibits disclosure to all persons, not just the perpetrator, and it covers any victim of criminal activity that qualifies for either a VAWA T or U visa. And so, as I said, it's not just the perpetrator and the disclosure of the prohibition, and that the protections apply from the time of filing permanently. They last forever through citizenship and beyond, unless the case is denied on its merits and all appeals have been completed. So, I think, let me see if this is the case. In a few moments, I'm going to be talking to you about the Hawk case, and I'll explain a little bit more about what that means in terms of denied on its merits. There are some limited disclosure exceptions. The predominant ones are to law enforcement and national security officials. They can only go solely for a legitimate law enforcement purpose. That law enforcement purpose is not an DHS immigration enforcement purpose. That law enforcement purpose is law enforcement officers at the state level or federal level that need it for enforcement of crimes, criminal crimes. So it's not the same. It doesn't apply to ICE. It applies to law enforcement officials and national security officials. And if the information is given to them, it has to be in a manner that protects the continues to protect the confidentiality of the information. So there have been a number of cases, federal district court, federal circuit court, and state court cases and family and criminal cases around the country on this. And I think I wanted to go over a little of the case law so you get a sense of what's covered. So what happens here is these cases come up because the perpetrator is trying to obtain information from the victim's case file in either a family court case, in a divorce case, a custody or protection order case, in a civil court case, so it could happen, let's say, in a sexual assault in employment, the EEOC brings a case and the employer tries to do discovery, or in a criminal case when the perpetrator is being prosecuted for the underlying crime, domestic violence, sexual assault, human trafficking, on other U-Visa criminal activities. So what the Hawk case said and what DHS policy said is it applies until the case is denied on its merits or unless. So this was a case, Hawk was a case in which it was a spouse abuse case in which the U.S. citizen spouse, Hawk, filed a family-based visa petition for his wife, and his wife separately filed a VAWA self-petition. It turned out in that case that she got her papers, her lawful permanent residency, through the application filed by Mr. Hawk, through his application. And in the end, she didn't need the VAWA self-petition because despite his threats, he continued with the case and she got her papers through his case. He then, in I think it was some kind of a custody or divorce case, wanted to get a copy of her VAWA self-petition file, which had been closed because of no prosecution because she didn't need it. She got her lawful permanent residency for her spouse, and the courts said that no, that the fact that it was never denied on its merits because she didn't need the self-petition in the end, didn't mean that the information contained in that case was ever discoverable. And they also ruled that his Sixth Amendment right to compulsory process did not give him access to VAWA confidentiality protected information, which they said was absolutely privileged. And that they said in a family law case like this that Hawk sued sued DHS to get the file, and the federal court said that that the primary purpose of VAWA confidentiality is to prohibit disclosure of confidential materials to the accused abuser, and that's exactly what he was trying to get around here. So it's a very good case. And then DHS instructions incorporated the Hawk opinion into the internal operating instructions of DHS on this fact as well, and that the instructions went so far as to say in criminal cases, the defense counsel may attempt to get the entire immigration case file as discoverable, but the entire file is not discoverable under this law enforcement exception. So they confirmed it, and essentially where the courts and DHS has landed is that the only thing that may be discoverable is the U-Visa certification itself, where it was done by law enforcement or a prosecutor. And this is the regulation that says when an agency, let's say a law enforcement officer in national security or somebody receives VAWA confidentiality information, they are bound to maintain confidentiality, and that's a regulation. And the fact that it's a regulation is really important because when there's a case for the judges on the call and the lawyers called U.S. Chevron, in which the Supreme Court requires state courts and federal courts interpreting federal statutes to give considerable weight and deference to federal regulations. And here we have a federal regulation on VAWA confidentiality binding the government. So it's not something that a court, if this comes up, they need to take it seriously under constitutional law, under Supreme Court law. In the Dimage, the next case I want to talk about was a custody case in a U-Visa. It was in family court in Connecticut, and it was ultimately appealed. And here they said he was trying to say that he was trying to discover the contents of the VAWA confidentiality case, saying it was relevant to credibility and impeachment. The family, they basically ruled, have many, every case I know of, courts have come out this way, that family court discovery is barred as contrary to the purpose of VAWA confidentiality. So in family court discovery, perpetrators should not be able to get the contents of any case, a U visa case or a self-petition case, even when the victim says that she's, as part of her case, she admits that she's been granted a VAWA self-petition. So the fact that she's seeking the protection, and that this case saw his trying to use discovery as interference with the victim's immigration case and federally barred. In the EEOC versus Coke case, this was an employer multiple sexual assault case where there were lots and lots of victims, and the court ultimately said that in doing discovery there has to be a balancing test. They have to consider the impact of compromising VAWA confidentiality on the U visa program and its goals and its protections, and the investigations and prosecutions more broadly, the chilling effect it might have. And they basically said discovery could only be conducted in a way that they could maintain anonymity. In this case, all they did was allow discovery of the U visa certs with no identifying information as which cert belonged to which victim. That's not possible in a criminal or family court case because you always know who the victim and the perpetrator is. So discovery in family court cases is generally barred. And as every technical assistance call that's come to us on VAWA confidentiality, we have materials and briefs and information, and everybody that we know so far that we worked with has been able to fight off discovery in these cases. So please do call us if you have a VAWA confidentiality case in discovery. Even in criminal cases, courts have ruled, this is from Maine, that there's insufficient justification when the victim testifies on the stand and she can be cross-examined to disclose any additional documentation to the defense when the defense was able to get a copy of the certification form. And that's all that could be done, and because they had an ability to cross-examine her, and that VAWA confidentiality laws, even in the criminal context, have a high level of protection given to those documents in the immigration file. And the last case I'll talk about has to do with, it's Alvarez versus Alvarez. It was a criminal case in California, and they ruled that the visa application and information was tangential collateral issue, allowing evidence about the immigration case of the victim, invited speculation about legal status, which was completely irrelevant to the criminal case. And that the trial court was well in its discretion to exclude evidence or any reference to the U visa. So there's, as I said, this shows you that there's very good case law on these discovery issues. So let's take a poll. So the first one is the U visa or T visa certification discoverable in a criminal case? How many of you think it's yes? More of you on the call than are there yet. So we've got a half-half. The answer is in a criminal case, the certification is discoverable especially when it's done by a police or prosecutor, because it's part of the prosecution's case. Number two, is information contained, can you move it over so I can see my general question? Is the information contained in the, hold on, there we go. Is the information contained in the victim's VAWA or U or T visa case discoverable in a state court case? And we're talking about like a state civil case. Correct. The answer is no. In the state court case, and in the family court case, you can put that one back up. You had it on there for a second. Nope. Okay, so this is the VAWA. This is correct. The answer is no. And let's just, I think, okay, did that one? It's the family court case one you had up a second ago. So how many of you think it's just, there? Okay. I think we got the general idea. Okay, thank you. Let's end the polls because I want to get on to the last topic. So the answer is that in the family court case, it is also not discoverable. Okay. Thank you, Marissa. Okay, so now we're going to talk about the last section, which has to do with immigration enforcement generally, sensitive locations, etc. And we start by talking about, as a precursor to that, talking about the bars and limitations on perpetrator-provided information, because the locational protections for victims are based on the non-reliance on perpetrator-provided information. So what you see here is that the government cannot gather or use information provided solely by any of these people: domestic violence, sexual assault, human trafficker, somebody is a criminal, conducted one of the criminal activities against the victim covered by the U visa, or their family or their associates. So somebody, they can't get their friend to call up and avoid VAWA confidentiality by having their friend make the call on them and against them. And that what's barred is that the DHS can't use this information to take an adverse action against the victim.
Leslie, before we continue along this new line, we did have a question from a participant on how should we advise a victim to react when they're being cross-examined by the defense attorney for the perpetrator, his attorney, regarding their legal status or potential application for a U visa. What's the best way to recommend that immigrant survivor react when asked those questions?
So I think one of the things that we are doing at NUAP under our OVW grants is we do training for prosecutors and law enforcement officials on VAWA, on working with immigrant crime victims. And part of that training has to do with training prosecutors how to respond when the perpetrator tries to raise immigration status in the criminal case, how to design your criminal case to be prepared for when the perpetrator might try to raise, say she's only doing this to get a U visa and things like that. So I think the key here is training prosecutors to not to expect that the defense counsel will raise these issues and design their criminal case around that. So what best practices are for prosecutors is that if the defense counsel raises, she's only doing this to get her papers, let's say, they'll actually create a timeline and show that the time she called police for help and the time she did her first investigative interviews with the with the police, she didn't even know what a U visa was. She only learned that when she got to the victim witness advocate in the prosecutor's office, or because she was got connected with a victim witness, a victim advocate in the community. And they can use that to get in prior consistent statements of the victim that they normally can't use in a criminal case. And when they do that, they start winning a lot of cases. And in some communities where they do that, the defense counsel stops raising the issues. So what I would say is I can make sure that in the materials I distribute, we have a set of tools for prosecutors that we've developed on this issue. Be happy to share them with them, but I think getting your prosecutors training and working with your prosecutors is the key to how to prepare, and working with the prosecutors to prepare the victims for that kind of cross-examining on the stand is, I think, what needs to happen.
Great. Thanks, Leslie.
No problem. And please, Rosie, if you could take a note so I don't forget to put that on the list, because I can't take notes and write at this and train at the same time. But we just published these, and if you have prosecutors or law enforcement in your communities that would be interested in receiving the training, they can send an email to info@nuap.org, and I'll add, Rosie, to the list an application form that law enforcement or prosecution agencies who want training can request a training, and we're looking for 9 new jurisdictions in the next couple of years to bring the training to.
Oh, great. We'll get that information out. Thanks.
You're welcome. So DHS cannot, what does it mean that DHS cannot rely solely on information provided by a perpetrator? What this says is that the DHS policies on this say that adverse information from a prohibited source, the perpetrator, is inherently suspect, and if the officer believes there is any credible evidence that the alien may be eligible for VAWA, U or T visa, confidentiality applies. That's what their policies have said since 2007. And as I explained earlier, this solely generally means that if the tip they get is she has a criminal history, that's something that they can independently verify and move forward on. But if the tip is not of that kind of thing that can be independently verified, then they can't, ICE can't, immigration enforcement officials can't shield themselves from VAWA confidentiality violation liability by saying, you know, that they called up some, you know, that they didn't verify it in some formal way. So what are the adverse actions covered by this? It means that they include using perpetrator-provided information to deny the victim's immigration case, to detain, deport, initiate an immigration enforcement act, seek out action, seek out, question, or detain the victim at any protected location, including a courthouse. And I said that already. And that whenever an officer receives adverse information from a spouse or family member or an unknown private individual, they're supposed to check this central index system. This is their policy I'm quoting from. And they're supposed to be sensitive to the fact that an immigrant might be subject to the victim-abuser dynamic, that might be at play. So this is the policy that says they're supposed to check the system. And so how the perpetrator-provided information bar is enforced is in a variety of ways. They get complaints from the Office of Civil Rights and Civil Liberties, and it's also enforced by the sensitive location bar. So now we're going to close out for the last 20 minutes and talk about the details of these sensitive location bars. And they are, I apologize in advance, but this is how immigration law is. These are complex. And when I often train judges, you know, the first question they ask is, are courthouses sensitive locations? And if you go Google, are courthouses sensitive locations, you will find a Q&A from ICE that says they're not. But there's a statute from that, and there's ICE other policies that says in the context that VAWA confidentiality makes them sensitive location as to victims. So again, these are not, they're a little bit complex. So I'll walk you through it. So the Prohibiting Immigration Enforcement at Sensitive Locations was designed to ensure that perpetrators and criminals can't use the immigration system against their victims by stopping them from accessing justice and accessing the whole range of victim services that are available from shelters and rape crisis centers and victim services programs, family justice centers, etc. And that if an enforcement action is going to be taken at a VAWA confidentiality protected location, they have to show, they're not supposed to do it absent clear evidence that the immigrant is not entitled to victim-based benefits. They're supposed to be properly handled, which generally mean they're supposed to go to a supervisor or general counsel to have them approved before they undertake the action. And this is where most violations occur. Many of the times, people will get tips. ICE or CBP will get Customs and Border Patrol or Immigration Customs Enforcement, and happen to either. They get a tip, and they follow up on the tip without checking the system. Or they check it and they ignore it, which would be a lot worse for them in terms of the violations. Hold on. Okay. So these are the sensitive locations of rape crisis centers, shelters, supervised visitation centers, family justice centers, victim service providers. This is providers of victim services to immigrant victims of domestic violence, sexual assault, human trafficking, or U visa criminal activity. Same thing with community-based organizations. It has to be people providing victim services for one of those types of crime victims. It's not every person whom that agency serves. And it also covers courthouses in connection with a protection order case, a child custody case, a civil or criminal case involving or related to domestic violence, sexual assault, trafficking, and stalking. So, for the dating violence folks in the audience, your dating violence would fit in under your state definition of domestic violence, if it does fit under your state domestic violence. So if you could get a dating violence victim could get a protection order under state law for dating violence, then it would fit domestic violence on this list. And we do have materials where you can look up what your state law definition is, but they're available from, womenlaw.org as well. And we have charts that track all the protection order statutes for this purpose. So courthouses are not considered sensitive locations by DHS except by statute, where DHS statutes and policies treat, Congress, federal statutes and DHS policies treat courthouse as sensitive locations with regard to victims of domestic violence, sexual assault, stalking, and human trafficking. DHS is required to certify to the immigration judge, as I said before, if they do an enforcement action at any of these locations, certify and prove that they didn't solely rely on perpetrator-provided information. So we're going to do another interactive opportunity here. So can we see the question, Marissa? Okay. VAWA confidentiality is likely to be violated when DHS officials come to the courthouse in response to a tip from a perpetrator and arrest a victim who has come to court in. So you have essentially 5 choices. They get seeking a protection order, for a child custody case, for an eviction case when the perpetrator stopped paying court-ordered rent by a protection order, and as a state's witness in a criminal case. So I know this one takes a little bit of thinking. I'll give you a few moments. Any other takers for voting? The answer to all of the above seems to be winning, which is exactly correct. So when a victim of domestic violence, sexual assault, human trafficking, is seeking a protection order, they're covered. And the only tricky one here is the eviction case. So if a victim is evicted because the perpetrator stopped paying court-ordered rent, and the rent was issued in protection order, then even the eviction case could become under this coverage. If it's an eviction case generally and the person isn't a victim or happens to be a victim, but there's not, any connection with the abuse, it probably wouldn't be covered. But in all of the other cases, it would be covered. Okay. In addition, so that's kind of the overview of the VAWA confidentiality locational protections. But those protections live in a world where there's also what these are called sensitive location protections. Those are protections that are governed by ICE policy. And for immigrant victims, sensitive location protections and the court. So there's three different laws at play here, or policies at play. You have a sensitive location protections. You have ICE limitations on courthouse enforcement that I'll go over that came out in January 2018. And you have VAWA confidentiality. So up until now, we've been talking about VAWA confidentiality. Victims receive, and the other two provisions, the sensitive location and the courthouse enforcement, apply to all immigrants, not just crime victims. So crime victims get the protections of VAWA confidentiality plus the other two policies, and I'm going to briefly explain what those other two policies are. So the sensitive location policy, this is a policy in which immigration enforcement actions by both ICE and Border Patrol are not to occur against anybody, any immigrant, at the following locations. So it's schools, medical and healthcare treatment facilities, places of worship, religious and civil ceremonies, weddings, funerals, etc., and public demonstrations. We've never seen a public demonstration case. Most of the cases that we see involving victims are happening at the other locations, the places of worship, schools, etc. And there are very, very limited exceptions to this policy. Exigent circumstances would be, a terrorist went to hide in a school. Again, not likely to come up in the context of victims. Prior approval by a designated supervisor. So there's a particular reason in this case to do it, again, highly unusual to happen. And, other law enforcement were chasing somebody and led ICE or CNPB to one of these other locations, also not common. What's important about these for the judges on the call and the family lawyers on the call is these are areas where to know that it's safe, so that if somebody is ordered to seek health care for their child, or if somebody is court ordered to do a visitation exchange, let's say at a church, to know that those are locations that are safe, I think, is important. Visitation centers, as you saw, were on the VAWA confidentiality protected list. But it's important to know because it could affect how people construct custody and visitation orders in family court cases. I did that already. Okay. So, and I just told you they come up, these issues. Any other ways that you can think about, the sensitive information and sensitive locations that might be helpful to courts? And then I do see there's a question about a victim charged with domestic violence. I'm going to hold that until the end, if that's okay. Anybody have any thoughts, Rosie, on how knowing about sensitive locations generally might be helpful to courts or victim advocates, et cetera?
Yeah, so this is important information that I think all of us can bring to our courts and, to our wider systems advocacy, efforts, because I think, again, these protections are only as good as our opportunities to really implement them and to make sure that victims are aware of them. There have been cases, I remember there was a case in particular in New Mexico where it was a judge who realized that it was, the perpetrator who had called ICE. ICE came into the courtroom and the immigrant survivor was seeking custody and was taken away. But for this judge knowing that this was a violation of VAWA confidentiality, knowing that it, came from the tip from the abuser had been threatening, that individual could be taken away and ultimately put into removal proceedings, because nothing really stops that from occurring unless all of us are informed and advocating and speaking out and making sure that these protections are enforced. So I think it is, really crucial to make sure that our court systems are aware of this and for them to know that there is, national TA and support that they can, call, who they should call if they see this happening in the court system or see these threats happening, so that we can make sure they're being implemented.
Right, and so that's where we're going to kind of conclude and talk about some of the details about courthouse enforcement, the Department of Homeland Security courthouse enforcement policy. that supports what this judge did in the case that Rosie's talking about, and I'll give you some detailed examples of how it works. So the ICE courthouse enforcement policy says that civil immigration at courthouses will only occur when the officers have information that leads them after a targeted immigrant, a particular targeted immigrant who will be present at a courthouse. So in order to be a targeted immigrant for courthouse enforcement, it has to be somebody with criminal convictions, somebody who's a gang member, somebody who's a threat to national security or public safety, who's been order removed and failed to depart, or who re-entered the country illegal after being removed. It has also been interpreted to, in practice, generally speaking, anybody with an open criminal case is also potentially at risk, although they don't directly fit into this policy. As you can see, this is the language of the policy. And so, and what they've also said in the 2018 policy, which anytime you're working on a case, so to those of you in court, working at courts and judges, I encourage you to print out this policy and have it in your courtroom. Those of you that are working with immigrant survivors who are advocates and attorney, I encourage you to print it out, take it with you, and have it on you should you encounter or your client encounter ICE at a courthouse, because it can be very helpful in triggering them to be knowledgeable of the fact that they may have violated the policy. It says that ICE will not subject to immigration enforcement people who are not targets. So if somebody goes to court with a family member, with a witness, or people accompany people to court, are not going to be subject, are not supposed to be subject to immigration enforcement according to this policy. Civil enforcement defined. So what is this? This covers actions to apprehend, arrest, interview, stop, or search an individual at a courthouse. And that the policy also clearly states that immigration enforcement officials who conduct immigration enforcement at courthouses are to avoid enforcement in areas within the courthouse that are dedicated to non-criminal proceedings. So they're not supposed to apply to they're not supposed to be coming into family courts, protection order, divorce, custody, civil court cases. And that if they're going to do any enforcement in a non-criminal case, basically the field office director or special agent in charge must approve it. It's possible within the policy that the field officer could, the special agent in charge or the field office director could designate an individual to give, under their supervision, to give these approvals, but it's not any ICE officer, and it covers a very high level of enforcement, and of supervisory approval. And I'm going to bring this back around because what I know is happening from what the people at DHS and ICE are telling me, and from the policies, these field office supervisors and special agent in charge who get these requests, the first thing they do is check that VAWA Confidentiality 384 database to see if there's a case been filed. So if there's a case been filed, they will stop things in its track right there. If it has not, they may continue against that person because they haven't been able to tell from their systems that this person is a victim. And they don't have to continue. They could still deny it, but they could. And so that's where, coming full circle, having the cases filed early really makes a difference in the system.
Yeah, thank you. Lesley, if I could also interject.
Sure.
You know, and I think what they're seeing, too, and one of the reasons that this policy really says they should not, be involved in these kinds of cases is because it doesn't only impact that individual immigrant survivor, but we see the tremendous chilling effect it has in the community at large. And not only that jurisdiction, these stories, when they get picked up in the media, it has implications far and wide. And it sharpens the tool of abusers who will say, you see, going to court, trying to get custody or trying to get order of protection, you run the risk of being deported. So I think even if a survivor, had not filed a case yet, there's still a strong argument to be made, and that's why they have to first go to the field office agents and get approval, and they should take into consideration, even if that person hadn't filed an immigration VAWA remedy case yet, what the horrible chilling effect would be in the community to take enforcement action.
Let me just say that the community effect is beyond victims. And then I'm going to kind of move to close out things and get to the last question. But we worked on a case. I did a training once where an officer raised his hand, and the question was, have you worked on a U visa case and how has it helped you? We were thinking that we're going to talk about victims. He stood up and he said, the U visa saved my partner and my life. And he told the story about a victim who'd come forth to get a U visa, who was the girlfriend of a gang member, the head of some big dangerous gang that these two officers had infiltrated. And the victim came forth on a domestic violence, got the certification on the domestic violence case, but then was still living with the perpetrator and heard that the gang had identified these two undercover officers as officers. And she called the U visa certifier up who'd helped her in her case and told them about the hit on their two officers, and the police department pulled the officers out of the case and saved their lives. So this has implications. These provisions were designed to help community safety in a broader respect and victim safety. So let me conclude by talking a little bit more about these courthouse enforcement provisions. So they say they're supposed to be planned. They're supposed to minimize impact on the court proceedings. They're not supposed to be in courtrooms. They're supposed to be in non-public areas of the courthouse, like the lockup facility. The places where this, if you talk to them about ICE about their policy, they want to be able to pick up, armed criminals at the courthouse where they've had to walk through the metal detector with their gun and don't have their guns. And that's what they'll tell you. But that's very different than, public entrances and hallways and things that are going to alarm the public. There is a way, these policies set a way for them to work with courts in designing ways to do whatever enforcement they need to do, but in a way that doesn't impact victims and doesn't impact court proceedings and allows people to get the justice they need in courthouses. And these are some of the things that courts around the country are doing based on the courthouse enforcement policy. The ones with the stars come directly out of ICE policy itself. And so some courts are restricting it. They don't allow immigration enforcement in the courtroom itself. Other courts only allow it in non-public areas. So they make ICE coordinate with the people in lockup and the bailiffs to pick up people who are criminal perpetrators at a time that it's not going to scare or disrupt other people. They ask them to use non-public entrances and exits. Many courts don't allow ICE in the courtrooms at all. And that they will, where it's a civil case or a family court case, the judges will basically say, show me your authorization from the ICE field director that you're entitled to be here, and often they can't produce it. And so these are things courts can do to make their courts welcoming places and to protect against officers who might overstep these policies or might not be aware of the policies. And the last thing I want to say is, getting to the last question, is what happens if the victim is charged. So victims who have criminal, who are in the NCIC because they have criminal convictions, it's not that they get no protections under these orders, but it's very difficult to make these cases work for victims. So it's really important, if you're working with victims and they have a criminal case, that if they can fight the criminal charge and not plea, it's best. If they do have criminal convictions, you have an uphill battle. You're going to need, that doesn't mean that perpetrators can provide information and get away with it without being subject, and that DHS doesn't have to follow VAWA confidentiality. They still do.